of the applicant evading or attempting to evade trial. There's no iota of evidence. It's just allegations that are there, and the reference that I've made regarding other co-accused stands to prove that indeed this may not be a factor as strong as the state alleges. Your Worship, when you deal with section 60 subsection 4C, the state's opposition is one line. There's a possibility that the applicant will interfere with the evidence. There's nothing else. We're talking here of evidence. No evidence was presented to this honorable court to the effect that the applicant at some point made such attempts. The proposition by the state is misguided and should be rejected. I submit, Your Worship, that this factor as well has not been established by the state. Because we're talking here, the law is quite clear, the position is clear. There has to be a likelihood. A likelihood is based on evidence. The applicant, on the other hand, is saying, I have no knowledge of the identity of the witnesses that are going to be called in of this matter. There's not been any evidence, once they are out, that there's been fiddling or attempt to position of bail in respect of even this provision. Section 64C, there is no evidence before you to suggest that the applicant will interfere with the investigations or intimidate witnesses whom she doesn't even know. There's not been, the only allegation close to that is that she knows some of the witnesses. Who are they? They don't mention. But to take it further and to disrupt the chain, should it be found that, oh, she knows a particular witness, so what? If evidence is not presented to suggest that her knowledge or proximity of this witness is an indication of some sort that she will in any way intimidate or interfere. We don't have that before us. I will move to section, and in this instance, Your Worship, pardon me, I have the authority of State versus Lamini, Dada, Jubek, Skitekat. That's the constitutional decision. In actual fact, that is the landmark decision based on but Your Worship, section 60 subsection 4D also find no applicability. It will undermine the, among others, bail system and everything. Where is evidence? And how, on what basis is the state relying on this, on that conclusion? Because for a conclusion to be made, there has to be a process to prove it. We don't have proof to that effect. Section 60, subsection 4E. And this is quite interesting because legislation deliberately starts with in exceptional circumstances. But in this instance, Your Worship, that if the applicant was to be released on bail, there will be public disorder. I think this point was also competently addressed by Judge Mhlambe in the bail appeal launched by the 3 co-accused in this matter. Then it was even a situation of few people demonstrating perhaps. But in this bail application, because she has a right to liberty, and there's not been any public disorder, at least from where the state in its own affidavit would have mentioned it. But what the state mentioned, Your Worship, in their own affidavit is simply that public disorder. That's it. Where they are just making mention of the fact that the applicant has been appearing with accused number 5, and she appears to be showing affection to each other. They were holding hands and smiling at each other. What is the state attempting to say? And what does that have to do with and in what state of the mind and in what during trial? Rather, the assertion by the state to the effect that it's a matter to conclude. Can I just approach my learned colleague? Your Worship, I've just canvassed this with my learned colleague. Just needed some.
Would you please just let me know when you're ready to proceed? I'm going to take a short adjournment.